Hey, moms and dads, John Hart from Cracking the Code, How to End the Financial Drain in Family Court. Really, it's a series about stopping the corruption, stopping the nonsense. This is a series about ending the nonsense. I'd like to say stopping the bullshit. I just don't put that in the headline so that I don't have any objections from YouTube. Let's talk about separation of powers, okay? In the United States, we have three branches of government. Anybody who went to third or fourth grade understands what the three branches of government in the United States are. It's the executive, legislative, and judicial branch. When you're in family court, you're dealing with the judicial branch that is judiciating over matters that are inscribed based upon the legislative text that has been written into law by the legislative branch and signed into law by the executive branch. That's it. So in your state, the legislature comes up with a law. They write the bill. Generally speaking, it's special interest groups or lobbying groups that write the bill. Lawyers write it. The legislative branch reviews it. And then they vote on it. And then the executive branch, the governor, for example, signs it into law. On the federal level, it could be the president signing a bill into law that came from the Senate or the Congress. And then judges have to listen to your arguments in court based upon whether or not your matter is antithetical or pro, whether your matter is supportive of the law that is written or runs against the law that is written. They're the referee. That's it. Just like a referee in the NFL, the referees don't write the rules of the NFL. The referees in the NFL don't determine what is considered holding or pass interference or unsportsmanlike conduct. There's a different entity, the National Football League, that generates these rules, and the referees are trained on these rules, and they're the judges, they're the referees. Same thing in court, whether it be criminal court, tort law, personal injury law, or whether it be civil court, such as family court. When you walk into your family court and you're dealing with your judge, they can't judiciate based upon them coming up with their own version of the law. It needs to be an objective reasonableness based upon the text, the legislative text of what is involved in your particular matter. When you walk into court, you have to make sure that you understand what the legislative text in your particular case has to say. And when a judge makes a determination in your matter, there needs to be a specific, articulable finding of fact supported by a specific and articulable conclusion of law. Not to say this is the same stuff using that language if you get pulled over by a cop, Terry versus Ohio, reasonable articulate suspicion, specific articulable fact. That's different stuff, but I'm using similar language. Don't let the judges and attorneys get away with legislating in the courtroom. That's where moms and dads fail too often. When you walk into court, you're going to square it up for the judge. These are the definitions that we are dealing with. Say you're dealing with a domestic violence issue. They can't redefine what domestic violence is. They can't redefine what violence is. They can't redefine what a familial unit is, what the word domestic means. So they have to prove beyond, with a preponderance of evidence if it's civil and if it's criminal, beyond a reasonable doubt, that there was indeed an act of violence as described by that state legislative context or body. And they got to prove that the person that violence took place with was indeed a family member. That could be your ex-spouse, it could be your kids and somebody you live with, what have you. Hold the judges to account and make sure that they are no longer continuing to legislate from the bench. Make sure that judges understand that you know the law, you know the definitions, and bring the law in your hands into the court. And before that court is adjourned, in your closing arguments, your closing statements, if you're speaking for yourself as a self-represented litigant, that is to say a pro se litigant, make sure that you are educating the court on what the law says, what the definitions are, and that they are expected to judge based upon a specific, definable finding of fact and supported by a conclusion of law that is definable and meets the definitions of the matter for which you are litigating. Stop playing games. This is not as hard as it sounds. Go to court, speak your mind, be respectful, but take no prisoners. My name is John Hart. This is Cracking the Code. Take care.